So today I want to talk a little bit about what happens when a client dies. So we are still in the middle of a pandemic. Also, the people that have wealth to invest assets are typically going to be older. So with that said, you're going to have a situation where your client dies. Let's walk through what you need to do. When you are first notified that a client has passed away, the most important thing that you need to do is make sure that you're no longer conducting any activity on that account. So when you're first notified, if you bill in arrears, you can final bill that amount through the date in which you were notified of their passing. And if you bill ahead in advance, then you want to go ahead and prorate and refund whatever the portion is through the date of notification of death to refund those client fees. Next, you want to put the account on a trade hold or do not trade, depending on your provider, and also notify the custodian. The custodian is going to do a few things. They're going to freeze the account. They're also going to turn off any electronic access to the account, and that's to protect the deceased client's assets to prevent fraud. What that also means, however, is if you have a deceased client that maybe they have a spouse as well, that's a client of yours, any of their individually owned accounts, they will not have access to. And simply put, they shouldn't. The person's dead. We should not be accessing their accounts or anything. And any type of access to the accounts needs to be done by someone who um, has demonstrated that they rightfully do have access to that account. So how is that done? They need to provide a death certificate, need to provide, um, if it is a taxable account, and there's not a transfer on death beneficiary, now we need to have the estate documentation and go through probate to figure out who is getting those assets. And they can provide that information to you so you can verify and set up that beneficiary with their own account and transfer those assets out of the deceased accounts into their own account. The same goes for IRAs. You want to make sure that your clients are completely filling out the beneficiary information anytime they set up a new account, because you need to be able to verify the date of birth or social of the person who comes to you after the client has passed away to say, hey, this is Sally Sue, this is the date of birth. Sally Sue provided me with her driver's license. I was able to verify, so we can go ahead and get her set up with her own account and transfer the assets out of the deceased account into her account. One thing to be careful about when you're dealing with deceased client accounts is to always make sure that you're talking to someone who is authorized. You still have privacy obligations to that account. So someone who's an ex-spouse or someone who claims that they're an executor, until you have information on file verifying the truthfulness of that and that they're entitled to that account and information about that account, you should not be providing any information. Don't feel as though, oh, it's my client. I had this client for 20 years and I have some obligation to shepherd their assets and maintain this account. That is not true. Your authority on that account really dies with the client. You can't invest assets when there's no client. You have no idea what the next person or beneficiary's investment objectives are to shepherd or steward those funds. Another thing to keep in mind is that your custodian has a lot more tools at their disposal than you do when it comes to deceased clients. Custodians can escheat the funds to the state after a certain period of time that the account has gone, stale. There has been no activity. Typically, it's a few years period of time, but don't feel that you have to maintain those assets on your book of business when you've been notified that your client's passed and there's no clear plan of succession. Maybe there was never a beneficiary named, or maybe you don't have the information to contact the beneficiary and the beneficiary is unaware that these assets are sitting out there. So in those situations, you can move to remove those assets from your book of business. And typically that's done by revoking your limited power of attorney over that account so that it would go to become a retail account at the custodian. Anytime you're notified of a client's passing, it can be a pretty sad occasion. And sometimes you're going to go into the defensive mode of, you want to protect your book of business and the assets you have under management. But after a client passes away is not the time to do that. So when your clients are alive, that's the time to form those relationships with their beneficiaries, so that when a client passes away and transitions, those assets can remain as part of your book of business. Feel free to reach out if you guys have any other questions about deceased clients, or even if you have a client that you want to fire. There's a right and a wrong way to do that. As always, good compliance is good business.